All right, well, it's 10:05, so I am going to get started. Again, thank you for being here again today. I do apologize again for yesterday. It was a lot going on, but not the right things. So just so you'll know, all of the sessions are recorded. And just so you'll know, tomorrow's session and Wednesday's session and Thursday's session will be recorded because I will be in a training all day tomorrow in Charlotte. The assistant broker in charge for our market center teaches. She's an instructor as well. And Thursday, I have coaching, and I believe she has appointments. So you'll get all of the information. So log on, tune in as you normally would, and you will get the information that you need concerning tomorrow's offer to purchase and contract and certain addenda. And Thursday will be policies and procedures. So that's the lineup for the next couple of days. Today, we will be going over buyer agency, the buyer side of a transaction and clients. Any questions from yesterday? If any of you were on yesterday, are there any questions or anything that needs clarification?
The form that you talked about that we need for compliance, and I didn't get it written down.
Okay.
Seller's net, is that compliance?
So seller's net, now I'll tell you, it's not, it will be listed in the, and I went back and double checked because as I am doing boot camp and things that we teach, because I am an approved instructor for the commission as well. So they highly suggest, and so does the North Carolina Association of Realtors, the seller net sheet, which I do every time. However, in our compliance and command, it's not in the list, and that needs to be changed. I suggest and highly recommend that every listing agent does a seller net sheet, and most agents do. You will see it in the list. It will be put in there. I'm going to add that as a conditional requirement. I would really like to have it as a requirement. A mandatory requirement. However, the agents have not been used to putting it in there, although they get it. So we'll probably go to a requirement. It's just a good thing to do and to provide to our sellers. Good question.
There was another form, I think in the disclosures that Central requires, and I did not get that one written down. I'm not sure exactly what it was, but I can go back and watch the recorded again if I need to. Okay.
Is it the mineral oil and gas rights or the residential property disclosures?
No, I know those are, but in the lead-based paint, if it's before 78, I know that one. And but there was a third form that you said was needed for compliance, and I'm not sure exactly what that was. So.
Okay, I'll go back to my notes. Codes, most common mineral oils, lead-based paint. All right, I'll go back through my notes and see what that is. Okay, all right. If it comes to me while I'm going through this today, I'll mention it.
Thank you.
All right, yes, sir. Okay, so today we're going to talk about buyer's agency, and we're going to do our best to wrap up at 11:30 because we have team meeting today. If we can wrap up sooner than 11:30, I like to give everybody time to get themselves together before getting on team meeting. Plus, our team meeting uses the same Zoom that we use here. So I want to make sure I give them enough time to do that. Okay. All right. That's perfectly fine, Melissa. Thank you so much for that. Thank you for making me aware. All right, so let me bring up our boot camp slide today. Slide. All right, there we go. Okay, let me share my screen here. And just talk to me. There we go. All right, so today we'll be talking about buyer agency. Buyer agency. With that, these are the forms that we will be discussing specifically: the Working with Real Estate Agents brochure, which we are all familiar with, and the exclusive buyer agency agreement, as well as something that our market center requires because we have a relationship with a title company. And the name of that company is Heritage Title. So there are disclosures, a disclosure and an election or selection form that must be received and filled out for every buyer that we represent, okay? Whether or not they choose Heritage Title or not, we still need to include it and get them to sign it, all right? So when it comes to the Working with Real Estate Agents brochure, today, as you all know, the North Carolina Real Estate Commission has split the brochure into two separate things. First of all, there's the questions and answers, the Working with Real Estate Agents questions and answers. Then there's the Working with Real Estate Agents disclosure for buyers. Two separate things. We are to give to our buyers the questions and answers. It's going to answer their questions on agency, dual agency, buyer agency, and it's redesigned for informational purposes. But that's not what we get them to sign and acknowledge. We get them to acknowledge the disclosure that we'll go over in just a moment. And in the buyer's agency disclosure, there are several options there. And that's buyer agency, typical standard buyer's agency. Then there's dual agency and then designated dual. We are to check each one that may apply for that particular buyer, okay? So that we will go over. Again, and on that form, there's what's called an unrepresented buyer. If that applies, we'll check that. And then something that I'll talk about is oral buyer agency. And you all know from pre-licensing that oral buyer agency is allowed in North Carolina. But if it is oral buyer agency, it cannot be exclusive. It's non-exclusive, which means a buyer is not tied to or married to you. They can go date all the other agents that they so desire. Once that exclusive buyer agency is signed, they are then married to you or married to the firm, okay? So buyer agency is allowed, however, it's no guarantee of payment for the firm. So we want to make sure we get buyer agency as soon as possible because we don't like working for free. I call agency agreements our employment papers. All right, we will also discuss exclusive buyer agency agreement. And these are some, this is a list of things that we're going to definitely focus on as we're going through the agreement. We're going to focus on the fact that the agency is between the firm and the client, although you all are a general agent of the firm. The main agent is the firm. You are the representative. Of course, it has to be in there, the term of the agreement and the dates. In order to be valid, we got to have a definite end date in there. So that's very imperative. We'll talk about compensation and other potential buyers, especially in this market. Buyers are going with the agent that can get them in there the quickest. So even if they've signed a buyer agency agreement with you, and I've seen this happen, if you can't show them a property and they're afraid it's gonna fly off the market, then they may call the listing agent or call another agent to let them in. We need to educate our buyers on that. So we'll discuss that. We will talk about the firm's duties, which of course is wrapped up in OLCAR: obedience, loyalty, disclosure, confidentiality, accounting, reasonable skill, care, and diligence. Other professional advice. We are real estate agents, so we're going to talk about how our advice is limited, and if there's other things that need to be found out or investigated, the client needs to go seek that from an expert in that field. We'll talk about confidentiality of offers and dual and designated agencies specifically. All right, heritage title. This is the last form that we'll go over today, forms. And these are forms that are required per our market center. First one is the disclosure, the heritage title disclosure. And this is the name of the form. So when you go into Command, create an opportunity, and you need to upload from the DocuSign forms, you need to upload the correct form. And this is the title of the disclosure. It's the KW 832 HT-BMC title, AFBA, which is affiliated business buyer agency disclosure. That is the title of the form. Best time to get that done is at the time of agency. So what I do is when I have buyer agency, a buyer's consultation, I'm going to print the working real estate agent's brochure and disclosure, as well as the buyer agency agreement and the heritage title disclosure, and just get that all signed at the same time. That's best practice. Now, once you find the property, you make an offer, the next form, that you're going to get signed is the heritage title selection form. And the title of that one, or the name of that form to upload into Command, is KW 832 BMC LLC Heritage Title Insurance Selection. If they select, you check the box that corresponds with their decision, and that's turned into the attorney. And we'll go through that at the end of the boot camp. All right. Any questions on the forms that we're going to go through?
So there's two forms on the heritage title selection.
Yes.
So one of them is telling them, it's a disclosure that tells them that we have a relationship with this company.
Yes.
The next one is them deciding whether they want to use that title company or not. Okay.
That is correct. You got it, Rusty.
And
That's
there's two places for each of those forms.
That is correct.
Okay.
And in two different places. So the heritage title disclosure is in the buyer consult, and then the selection is in the under contract.
But if we make an offer on it and it does not get accepted, then we don't load that particular one. We have to get them to sign a new one on the next offer.
Good question, Rusty. That's a lot of work. So my suggestion is
no doubt about it.
Right, exactly. My suggestion is to get one. So at the time of offer, that's when they can be making their decision of if they'll use it. So if they'll use it for that one property, if I wouldn't put the address in there yet, I would just get them to sign it at that time, to sign saying they're selecting, and then complete the address once their offer is accepted.
That makes sense. Thank you.
Yes, yes, sir. Good question. Very good question. I'm all about simplicity and efficiency, not doing double work. All right.
Me too.
You're welcome. Any other questions before I actually bring up the forms and we start to go over those? All right, so I'm going to stop sharing here and let's get out of that one. And let's go over here to our forms, and the first form we're going to discuss is working with real estate agents. There we go. All right. Here, here. All right. Okay,
I'm sorry, I have so many questions.
that's
The
good.
command normally fills in all the information.
Yes.
Is it going to fill in the address and we're going to have to take it out? Or is it going to be blank and we have to fill it in?
Yeah, so good question, Rusty. Because these are PDFs and it's not an actual DocuSign template, we're actually going to have to fill it in ourselves. So we can do that when we're sending it to them electronically. We can put a text box in the form and put the address in that way. Of course, we can print it, right, and fill it in and then re-upload it. But either way, DocuSign will allow you to fill it in. We can only fill it in once we create the envelope in DocuSign and prepare it to go out for signatures.
That works.
Yep. All right, good questions. Okay, let's share screen. And which one am I sharing? I am on WWREA. All right, there we go. Can everyone see the screen? I know technology can be fickle sometimes. Thank you. All right, so working with real estate agents, that's for sellers. It's a double-sided form now. So the first side is for sellers, second side is for buyers, which we're going to discuss today. All right. What I like about this, it is very clear at the very top in the first box, and it says this form is not a contract. And signing this disclosure only means that you've received it. That's important for our potential clients to know, because there are times when we may be working with a buyer and it may very well be oral and they decide not to sign buyer agency. They may want the freedom to date other agents. So, however, that does not excuse us from disclosing them. So one important thing to know, of course, this is not a contract. It's merely acknowledgement, okay? All right, I like this last box in that, or the last bullet in the box that says, do not share any confidential information with a real estate agent or assume that that agent is acting on your behalf until you have entered into an agreement with the agent to represent you. Otherwise, the agent can share your confidential information with others. That is very important. So once a client a potential client starts to share personal confidential, information, we are to stop them and Mirandize them. Anything you say can and will be used against you. I can use this if you do not have agency with me. So it's important that they know that. Now, another important note right at the bottom of the bold box, it says or gives a note to the agent. And this is what we need to make sure that we're doing. We are to check all relationship types below that may apply to this buyer. That may apply. So it's not just checking the box for buyer agency. It's actually, we should be checking all boxes that could potentially apply. So usually it's mainly the buyer agency, which we understand that the firm will represent a buyer in a transaction and be loyal to that buyer, okay? It also goes on to say in this first box that you may begin with an oral agreement, but your agent must enter into a written buyer agency agreement with you before preparing a written offer to purchase or communicating an oral offer for you. So that's the thing for buyers to know. We can work off of oral buyer agency until the time of writing an offer, at which point it has to be reduced to writing, okay? That last sentence says the seller would either be represented by an agent affiliated with a different real estate firm or be unrepresented. And we'll talk about that more in this last box, all right? In the second box here, under dual agency, for our firm, we need to check both boxes because both of these types of relationships can apply. Of course, dual agency, if they do not allow, and we'll talk more about that in buyer agency, I'll hold off on that. In this particular case, our firm does allow dual agency. We practice dual agency, and we rather all agents practice designated dual. And we'll talk more about that as well. Now, although it briefly describes what these two are, dual agency and designated dual, when we give them the disclosure, not the disclosure, the questions and answer, that's going to give them more detail of what dual agency is and designated dual. Okay, so allow that to explain each one of these. We can explain at a high level, but if they have questions, that questions and answers portion of the brochure definitely helps, okay? And then this last box, unrepresented buyer, which is seller sub-agency. Now, our firm does not practice sub-agency, seller sub-agency. We do not practice that, and we do not compensate sub-agents of the seller. So this would not apply, okay, at our particular firm. Well, let me say it like this. Seller sub-agency doesn't apply. However, our firm, well, yeah, I guess I'll say that. We don't practice seller sub-agency. Every buyer must, or every agent must represent somebody, okay? Now, here's the thing. Say there's a buyer that comes and doesn't want representation, okay? We can, and here's the thing. Even though we don't, this would apply even though we do not compensate seller sub-agency, and let me explain. At all times, the agent must represent somebody in a transaction, okay? So if you're a listing agent and a buyer comes, they don't want representation, you're just going to be the listing agent and not representing the buyer. If a buyer comes to you and you're not the listing agent and they want to make an offer, what would you do at that point? I'm curious. You all talk to me. Buyer comes to you. They want to see a property within our firm and you're not the listing agent.
Well, I thought you said we were the listing agent.
Well, you are, your name isn't on the listing agreement as the representative.
We would have to explain to them that our firm does not work with unrepresented buyers, and tell them that we would have to go in under agency agreement.
Exactly. Were you about to say something, Emily?
No, I'm just agreeing.
Okay, very good. Exactly. If that is the case, they are going to have to choose buyer agency. And we're going to have to convince them, right, of the advantage of having a representative on their behalf. because our firm does not compensate subagents of the seller. So we have to have buyer agency. And same thing, if someone comes to us and they wanted to see another firm's listing, they wanted to write it up. However, they are choosing not to go under buyer agency. Well, what we could do at that point, you could do one of two things: convince them to the advantages of buyer agency, or we can refer it to that firm, do nothing, and get a referral fee. That's another way of doing it. But yes, we do not compensate sub-agents of the seller. We have to have buyer agency for our clients.
I've been successful in the past telling them, I'll just represent you on this one property. And when you write up the agency agreement, you write it up for the single property. This way you're not tied to me.
I love it. I love it, Rusty. Love it, love it, love it. And it's so good that our agency forms are written exactly that way, so we can do that. I love that. Love, love, love. Okay, Melissa's gone. All right. Did she leave? Yeah, she left us. Okay, great, great, great. All right, very good. And of course, at the end, we're going to have the buyer sign, have the buyer date, and we will put our name there. You'll put your license number there and the name of the firm. Okay.
So my understanding before was that if dual agency was checked and designated dual agency was checked, buyer agency was assumed, but that's not the case. You want buyer agency checked as well as dual and designated.
Yes, that is correct. That is correct. Absolutely. That is correct. Very good. Very good. All right. Good questions. Any other questions before we move on to the exclusive buyer agency agreement?
No, I don't.
Okay. All right. Very good. So let me stop sharing there and move on to, let's see, that go away, buyer agency. Here we go. All right. Share the screen. Here's buyer agency. There it is. Okay. All right.
Wasn't it easier just to do it in person?
I tell you, I would, and you know what? We started out that way. We started boot camp last month and I was there and no one showed up. So I did it in the training room from Zoom, just me by myself. But it's interesting that this falls on the same week as we have team meeting. So on Tuesdays are pretty much always are going to be abbreviated, but we'll get through as much as we possibly can. All right, share screen. Why is it not? I don't know what's going on here. Okay. Go here. There we go. All right. Are we good now? Can you see exclusive buyer agency?
Yes,
Yes.
I can see it.
Okay, perfect. Thank you. Okay, so this is the exclusive buyer agency agreement that we will use. One thing I'd like to point out, I'm going to scroll to the bottom. Always make sure we are using the most updated form. So this form is standard form 201, which the 200 series are the buyer forms for per the North Carolina Association of Realtors. And it says that it was revised in July of 2021. So next year, we will use this form, of course, for 1 year. Once July of 2022 comes, we will be required to use the new form if there are any, okay? All right, going back up to the top. Here, It says this exclusive buyer agency agreement is entered into, of course, you're going to put the date there. And it's going to be between the buyers and the firm. So if it's one buyer, you put the one buyer's name in. Of course, if it's multiple buyers, it allows space for two. But if it is more than two buyers, there is a addendum for that, where additional signatures may be required, okay? So we can put in as many names here as we possibly can, and if additional signatures and names are needed, there's a form for that, okay? All right, Keller Williams Central, of course, is the firm name, and that's who the agency agreement is with. If it is a entity buyer, we need the entity's name there in the buyer's line, okay? And whoever is signing should be a representative of the entity and have the authority to bind that entity as a buyer to this agreement. All right. Now we're going to move on to section 1, paragraph 1, which is the type of property. Of course, whatever the buyer is looking for, if it's residential or commercial or some other type of property, we're going to notate that. 1A speaks to the general location. Here, we've put in Orange County. And B is other. And this is the section, Rusty, that you would put in for whatever particular or specific property, I'm assuming, in that scenario that you gave us earlier. And it would only be for that one particular property. All right. Paragraph 2 talks about the effect of the agreement. And it simply says that by employing the firm as the buyer's exclusive agent, buyer agrees to conduct all negotiations for such property through the firm and to refer to firm all inquiries received in any form from other real estate firms, prospective sellers, or any other source during the time this agreement is in effect. Right here, number 2 is very important in our market, in our particular market, because there are a lot of buyers who are getting antsy and may not understand that it's Sunday at 4 o'clock and you're spending time with your family and you're away and they want to see a property and they're desperate because they think the property is going to not be available the next day. They may contact someone else. So we need to educate our buyers that when you sign this buyer agency agreement, you're agreeing that all negotiations, inquiries, anything comes through the firm. So we need to make sure we educate them on that, because I've had this happen with several of our agents. The buyer sign exclusive buyer agency and then goes and signs another one with another firm. And this paragraph was not explained to them. So make sure we're doing that and really educating our buyers. Paragraph 3. Oh, let me back up. In addition to 2, I've had situations where the buyer, although they didn't sign anything right away with the new agent, they were working with 2 separate agents and had both agents writing offers, which means at some point prior to that offer, exclusive buyer agency was signed with both of them. And one was showing them the same property that they had the other agent write an offer on, and the offer was accepted. And so then we get into procuring calls and what the code of ethics say. So just make sure you educate your buyers, and it's going to could possibly save a lot of headache in the future. Okay.
I had that happen to me where
Really?
the listing agent called me and said, I've got another offer from a different firm for the same name.
No.
And I was like, and I had explained it to him. He just thought he was working the system.
Ah, I'm telling you, Rusty, a
So
lot of that is going on.
So I let him go. I mean, I called him and I said, look, you can't work with two agents.
Yeah.
This is not what we talked about. So
Uh-huh.
I'm just gonna let you go. So, yep.
Yeah. And you know what, Rusty? I believe, thank you for sharing that. I believe that's probably the best thing because that client is already demonstrating they may be more trouble than they're worth.
That's exactly what I was thinking. Yep.
Yes, 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 yes. Well, I applaud you for that. Yes, well, I'll let you go on that. Absolutely. All right. Yeah, so they're even ignoring, even though we're educating, they're ignoring the things that they're being told. Well, thank you for educating that client. All right, paragraph 3, term of agreement. Of course, it's going to begin on a specific day, typically the day that's up there in the first section of the agency agreement. And it will extend to one of two choices. Either they're going to buy a single property. If they're buying a single property, you check the first box. If they're buying multiple properties, and it could be an investor who's purchasing more than one, then the agreement shall terminate on some date in the future. So just make sure you have, in regardless of the box you check or that box that applies, make sure there's a definite end date in there. I've had an agent that completed it, and technology is technology and it works when it works. And when it doesn't, we don't ever understand why, but for some reason it kept pulling the date out of there. I don't know why. I guess it was a glitch in the system. And they went and made an offer on a property she had introduced them to and wanted the firm to, seek the compensation for it. Well, when I went back to the agency agreement, it didn't have a date in it. There was no definite end date, which means it's not a valid agreement. So that's one thing I want to caution you on. Even though technology is great and it works when it works, make sure there are dates there. Just go back and double check the technology.
You always have to check your forms. Always.
Always. Yes, definitely. Always check your forms. I don't trust technology like that. I tell you, I don't.
I don't either. No.
Oh, very good. Yeah, always check the forms. Okay, moving on to paragraph 4, compensation of the firm. 4A, some agents may and have started running their business where they charge a retainer fee. And I'm seeing that more and more lately. And if that is the case, it says it's a non-refundable fee of whatever the amount is, which shall or shall not be credited toward any compensation due firm under this agreement. So that's going to depend on how you run your business. If you choose to charge a retainer fee, whatever that amount is, put that in that blank. Some agents are starting to do that. And we actually have policies on that depending on the amount. Certain amounts we won't apply a, split to or a transaction fee. And we'll talk about that on Thursday in the policies and procedures day. All right, 4B is where we will put in the fee that we charge for our services. And so BI agrees that firms' fee for services hereunder shall be an amount of, and whatever that is. Our firm charges 3% to buyers. We expect 3%. It can be lower. However, if it's lower than a 1% difference, we like to for you all to come to me and we'll discuss it and have a discussion on what that would look like and how we can do that. So 3%, we that's what we expect. And if you go under 2%, you need approval for that, okay?
So 3% is the firm's expectations.
Uh-huh.
If we go down to 2.5%,
Mhm.
during negotiations, we're all right. But if we go down any lower than that, we need your permission.
Yes, we need to get
So
approval. Yes.
is it okay to put 3% of contract sales price or whatever's in MLS? Or
Yes.
just,
Yes, you can put that in there. Yes.
okay.
Yep.
Okay, good deal.
Yep. Whatever's advertised in MLS. Absolutely. Very good. Very good. And I'm seeing now some builders are and existing are paying out 2%. I'm seeing that more and more, especially in the triangle. I'm seeing 2%. And then
They're
I'm
whittling our commissions away.
I know, exactly. And there was one builder, they were only paying out 4,000, period. It didn't matter what the sales price of the new construction was, $4,000. So yeah, we're here to protect our commission. Absolutely. All right, 4B1 says that the firm shall seek the fee from a cooperating listing firm through the listing firm's offer of compensation in MLS or otherwise, or from the seller if there is no listing firm, and the buyer agrees that firm shall be entitled to receive the same in consideration for firm services hereunder. So 4B1 lets them know where we seek the compensation first. Now 4B2 says if the buyer purchases a property where the compensation offered by the listing firm and or the seller is less than the fee, or where no compensation is offered by the listing firm or the seller, then the buyer and firm agree that the buyer will pay the difference between the fee and the compensation offered unless prohibited by law. Firm will timely inform the buyer if the compensation offer is less than expected. So if you are adamant on the 3%, but the seller is only paying 2%, when that buyer signs this agreement, they need to know we're expecting, or that you are expecting, you and us, the firm, that additional or that difference in the commission. And there are some agents who are successful at conducting their business that way. So it's going to depend on how you run your business, but you can let the buyer know that you expect the difference, okay? All right, 4B3 speaks to additional compensations. If there's any bonuses or anything offered, they allow you to receive that, okay? And if there are such offers, then we are to let them know, make the buyer aware no later than at the time of offer. All right. 4C speaks to when compensation is earned. All right, so C1 speaks to during the term of this agreement, buyer or any assignee of the buyer or person or legal entity on behalf of the buyer, if they're going to purchase, option, or exchange, anything like that, regardless of the manner in which buyer was introduced to the property, compensation is deemed earned. So under exclusive buyer agency, it specifically says, regardless of the manner in which the buyer was introduced, their friend can tell them about the property. Maybe they go see it with the friend. Doesn't matter. When they signed this agreement, they said that and agreed that our compensation is due or is earned, regardless of if the friend told them about it, introduced them, or if we did, okay? 4C2 says if within, and it's up to you how many days you put in there. Here we chose 30. If within 30 days after expiration of this agreement, it's called the protection period, the buyer enters into a contract to acquire property introduced to buyer during the term of this agreement by the firm or any third party, unless the buyer has entered into a valid buyer agency agreement with another real estate firm, it's deemed earned. So even if this has expired and it's 25 days after, and they enter into a contract with a property that we've introduced to them or anyone else, we've earned compensation, okay?
This is a very sticky point.
Very. I've had it happen with several agents, very sticky, very, very.
So is the firm
Mhm.
going to seek this compensation, or do we as a general agent of the firm get to make a decision and say, nope, I'm letting this one go? Or, I mean, how's that work?
Okay, so very good question. And at this point, if this is the case, I ask that you bring it to me. We're going to discuss it, and it's what you just said, Rusty. We're going to talk about, number one, I want to know what the agent wants. What does the agent expect? What would they like to see happen? If the agent says, I want the compensation, well, at that point, we're going to work on your behalf, which means we have to have all of our ducks in a row. And I've done this, and I've had to eat certain, because the documentation was not there. So if this is the case, and this is something that you would like to pursue, then bring it to me, we'll discuss it. And if we are solid on our end, then yes, we'll go after it. We'll seek it. Absolutely.
Thank you.
Yep. Yes, sir. All right. C3 says it's deemed earned if, having entered into an enforceable contract to acquire property during the term of this agreement, buyer defaults under the terms of that contract. That's another thing. Buyer defaults under the terms of the contract, compensation is deemed earned. Okay, is earned. All right. Do we always get it when a buyer defaults? Probably not, because if they're not going to buy the property, I'm pretty sure they're not going to pay the firm. But that's something that we can discuss and potentially seek. Okay. 4D says the compensation will be due and payable at distribution of proceeds. Of course, that's closing, or upon buyer's default of any purchase agreement. So due and payable at closing or at the time of a buyer's default, if that applies, okay? So if the buyer defaults, the total compensation that would have been due the firm will be due and payable immediately in cash from the buyer, okay? No assignment of rights and real property obtained for buyer or any assignee of buyer or any person or legal entity acting on behalf of the buyer pursuant to this agreement shall operate to defeat any of firm's rights under this agreement, which simply means if the buyer assigns the contract over to someone else, they cannot defeat the firm going after compensation if it is due. Okay. All right, 4E speaks of attorney fees and costs. If it goes that route, hopefully it will not, but if there's any legal proceedings, the prevailing party will, the firm shall be entitled to recover it from the buyer, if that's the case. And 4F speaks to if buyer purchases unimproved property, agent may assist buyer in identifying a contractor to make improvements. If that's the case, then the contractor may offer to compensate the agent or the firm. And if that's the case, the agent will disclose that to the buyer, okay? All right, any questions on firm's compensation? When it's deemed earned and when it is due and payable?
No.
Okay, very good. All right, off to paragraph 5, which talks about other potential buyers. And yes, there will be other buyers prospective buyers that you may personally have, or that the firm has, that will be looking at the same property that this specific buyer may be viewing. So just so they know that, and of course that happens too in this market. You may have 2 buyers or 3 buyers looking at the same property. So just so they know, there are other buyers viewing the same property that they will be. All right. Paragraph 6, firm's duties. And what I won't read this paragraph here, but I will say that our duties are summed up in what you learn in pre-licensing, OCAR. That's our duties in a nutshell. And let's make sure that we are representing our clients and giving our clients fiduciary duties that are due to them, even if our services are limited. Even if we limit our services, we cannot limit or reduce our fiduciary duties, okay? All right. Paragraph 7, disclosure of buyer's name and mailing address. Of course, there are times and different vendors that require the buyer's name and mailing address and contact information for the buyer. Then we will have to do that. They need to be made aware of that, okay? All right, and it just goes on here in 7B to talk about the general statute of that.
But typically, you don't put the buyer's name, address, email, phone number, all that on a contract.
Right. That is correct. That is correct. I do not do it. I think it's best practice not to, because Rusty, I tell you, that can open up a can of worms for other parties to contact your client, and we don't want that. So yes.
Share that with the attorney, but no one.
Exactly. That's right. That's exactly right. All right. Okie dokie. It also speaks to earnest money. If there's any earnest money that has to go back to the buyer and that sort of thing, you know, we can give that information for it to be sent. But again, if that's the case, go to your client and ask them. Although it says we have permission here, I like to get permission from the buyer for every little thing when it comes to that, just as a best practice. All right, paragraph 8 speaks to discrimination. We cannot at all, as agents, is federal law, state law, practice discriminatory activity. So no discrimination, that's in all of our forms, it's in all of our agency agreements, okay? And we are aware of that. And the other language that they've added is sexual orientation and gender identity, okay? So just make sure we are aware and make sure we are abiding by federal and state laws. The warning box here speaks to those love letters that buyers like to write in order to get their offer accepted. I caution you all to caution your buyers on writing them. We can't stop them, but if they do, we want to make sure we are not participating in that. If your buyer wants to write such a letter, I would almost have them send it to the seller themselves, or ask the listing agent, how do you all receive these buyer letters? Very, very sticky and controversial subject right now.
I thought this was deemed not good practice by the commission, that we should not do this.
Mm-hmm. And
so
you know,
I've been telling my clients no love letters.
Rusty, I applaud you. That is correct. I tell my clients no love letters. I will not deliver them. That's how I've been running my business. Yes, commission can't say whether or not, because there's no law and no rule on it, they frown upon it and they don't recommend them. However, we can't, there's no law against them, but it could violate and cause someone to unintentionally discriminate.
No doubt.
Right. So that's the thing. And I don't want any parts of that. None whatsoever. So my opinion, and this is what I tell all of our agents, best practice is to leave the love letters alone. I won't deliver them. If you want to give a love letter, deliver it to the seller, know where they live, you know the address. Go there, but I don't participate. Yeah. I think that's just best practice. Have you ever received one, Rusty or Emily?
I have not. When I got out of real estate in '09, that wasn't really a thing. That
Okay,
wasn't really being done, not in the area I practiced.
gotcha.
When I first started, I used to encourage my buyers to write that to separate us, to put some distance between us. But no, after the commission started frowning on it, I was like, nope, I'm not going to do this. I'm not going to participate. If you want to deliver one, you may,
Right.
but they don't know the actual buyer. They don't know the actual seller's name and stuff.
Right.
Okay, so and I'm not going to give it to them.
Right, exactly. I don't deliver those. Yeah. Okay. Very good. Yeah, you're right. In the past, they were really good and effective, making a buyer stand out. But today, with all of the, social unrest and all of that, it's just not good practice to do. Yeah. Very good. Thank you both for sharing that. All right, paragraph 9, buyer's duties. The buyer agrees to cooperate with the firm in the acquisition of real property described above in that first paragraph, and is included but not limited to, of course, working exclusively with the firm, referring to firm any information about the properties that they find or interested in, complying with reasonable requests, of course, being available for showings, examining properties only by appointments made through the firm. That's another one. Educating those buyers, conducting all negotiations through the firm, due diligence through the firm, and paying for products and services that they may have, or examinations or investigations that they may have. They need to agree to that. So making sure the buyer is aware of their duties. 10 is huge. Other professional advice. We are not CPAs or attorneys or tax advisors. We're representing them as a real estate agent on behalf of our firm. All of those other advice and professional services, we do not provide. We're not inspectors. We need to refer them to the experts in those areas. If we can refer them and use a professional services disclosure, whether they elect to do it or not, that's where we keep track of that. But we stay in our lane. We're not lenders. We are not to advise them on which product is best for them. So we need to make sure that we, handle that and let them know that and educate them on that. Of course, we are not here we're not just supposed to check the boxes that we've sent them a sample of the offer to purchase or question and answers on home inspections or the professional services disclosure. We need to check the box, but be honest to it that we actually do send that to them. I've seen where this has come into play when there have been complaints or potential or threats of complaints. And we need to make sure we have all of our ducks in a row, okay? So not only checking the boxes, but making sure we actually do provide them.
So when you DocuSign someone, and you send it electronically and you send all these forms with it,
Mhm.
is that count as being sent to them?
Yes. Yes,
Okay,
it does.
because
Yep.
they do retain that information. Is that, they do, right? I mean,
Yes.
they are able to keep, okay, good.
Yes, they are able to keep that. And the good thing about that, DocuSign, has a history of activity. So we're able to see what was sent as well. So that's why that does count. Absolutely.
Good deal. That's the way I, that's the way I
Yes,
do it.
very
Okay.
good.
I've got one question.
Okay.
How do you go through the review of this using, being sent through DocuSign? I'm used to the old school. You print it out, you go through line by, each section like you're doing right here.
Yes, yes. And I'll tell you, for me, that's a good question, Emily. For
Mhm.
me, I send all of this stuff up front before the buyer's consultation. I'll send it up front, and I also have a PowerPoint presentation. I send it to them up front, send them the sample copies, and I tell them when we meet, I need you to review this ahead of time, because when we meet, we're going to go through this and we're going to talk about it. And whatever questions you have after reading it, when they don't have any questions or things like that, I know they've probably not seen it. So that gives me the ability at that point. The highlights are a part of my presentation. So it is covered, but not in a line by line manner.
I don't,
Okay.
I don't do it line by line, but after I send it, I call them and I say, do you have any questions? Have you looked over the offer to purchase?
Yes.
Have you looked at the questions and answers on the home inspection? And do you have questions about that? And like you said, if they don't have any questions, I know they haven't read it yet. So I go ahead and cover the highlights with them. And then I say, okay, this is the professional services disclosure and elections form. And you need to decide who's going to do what during this transaction. So, I mean, that's the way I handle it through DocuSign.
Yeah. Either way, I like both ways. I'm like you, Emily. I got some old school as well as efficiency through technology as well. So either way, so long as it's done, is my.
I like your idea. I like the PowerPoint and send it in advance, and then you can review it in person.
Exactly. Yep. Love it. Love it. Love it. All right. Very good. Very good. Thank you both for sharing. All right. Paragraph 11, home warranty. This speaks to, and our firm does not have a home warranty company that we have a relationship with to where we will get some type of fee from. So for us as a firm, that number will be 0 in that blank. However, that's not to say you as an individual agent can't develop a relationship with a warranty company and get something in from you, get a fee from them. If that is the case, then that number will go in there. But as a firm, we do not have a warranty company that we receive a fee from if we refer someone and someone buys. Okay.
I thought that was outlawed by the commission. Compensation for referrals to warranty companies and such, is it not?
It's not in the form of a kickback. Yes. If so, for instance, and I'll just read, and reading through this may help to explain it. The seller of any property buyer may be interested in buying or may not may or may not provide a home warranty. If the seller does not provide a home warranty, buyer may elect to purchase one. Buyer understands that although firm will assist buyer in identifying available home warranty products, buyer must refer specific questions regarding coverage afforded by any such product to their provider. If firm assists buyer in obtaining a home warranty, a fee of blank will be offered to firm by the person or entity through or from which any home warranty is obtained as compensation to firm for its assistance. So this is saying if you sell a product, if we sell them a warranty and they choose to buy it, then that warranty company can give $100 gift card to the firm. If they give it to the firm and it's discussed and agreed to up front, it's not a kickback. Does that make sense?
Perfect sense.
Yep.
That makes great sense. Yep.
So we're letting them know up front. However, we don't have any. Our firm doesn't have any. So for us, it's going to be zero again, unless you, as an individual agent, seek to do that. But here's the thing, it needs to come to the firm, not directly to you. All right. And the firm will in turn give it to you, the agent. Okay. All right. Good question. Paragraph 12, confidentiality of offers. We know we have to keep all offers confidential. Per the commission, we cannot provide or share any material terms to anyone else unless we have the express permission from our buyers or any other clients. So everything's confidential unless we get get the buyers or clients' permission. Okay. All right. Paragraph 13, additional provisions. Most times there are not any additional provisions. However, for this particular example, we just put one in there. As an example, buyer must have a property with a dog run for their 7 dogs. So a buyer may say, and in this particular case says, as a part of our agency agreement, I must have a property with that has a dog run or have enough room for a dog run. And they may want that to be a provision of this agency agreement. If we choose to do it, then this is where we would write it. Okay.
If there's not any, put NA in that line.
That is correct, or none, NA or none, absolutely. All right, very good. We're almost to the end. Paragraph 14 speaks to dual agency. All right, so dual agency will arise if the firm has the seller, has that listing, and has the buyer. So when it comes to dual agency, 14A speaks to the disclosure of information. And it says, in the event firm serves as a dual agent, buyer agrees that without permission from the party about whom the information pertains, firm shall not disclose to the other party the following information: price, terms, and conditions of a sale, motivation of the party, and any information about a party which that party has identified as confidential. So we cannot share any information without the permission. All right. 14B speaks to the firm's role as a dual agent. I won't go through every or won't read this entire paragraph, but of course, our role as a dual agent means we represent the seller as well as the buyer in a transaction. All right. And we will do our best, of course, as a firm to represent both equally in a fair way, which is why we, as a firm, as a policy on that agency agreement, we want dual agency. If they choose dual agency, we want dual agency, and we would like each agent to be designated specifically to that particular client. Okay. We have so many agents and information can be given so easily and so quickly. So as a firm, our policy is that on our agency agreements, we check dual and designated dual. 14C speaks to the buyer's role, how they are to conduct themselves in a dual agency situation. Several things I want to point out here is that the buyer has the responsibility of making buyer's own decisions as to what terms, and that's in any role, whether it's dual or not. We are not to make decisions on behalf of our buyers or our clients, period. That's the buyer's decision. And number two, buyer's fully aware of and understands the implications and consequences of firm's dual agency role as expressed herein to provide balanced and fair representation. As designated agents, we are able to do that in a better manner. Okay. 14C3 says that buyer has determined that the benefits of dual agency outweigh any disadvantages or adverse consequences, which means, especially in the Alamance area, our firm has market share. We're the largest in the area, so it behooves every buyer to select dual agency. If they don't, they're going to be missing out on a lot of listings. 14C4 says buyer may seek independent legal counsel to assist buyer with the negotiations if they so need it. Okay. Thanks, Emily. Hope everything
Thank you.
goes well. Okay, have a good day. All right. Moving on this to 14D, here is where the buyer, of course, is going to select whether they agree to dual agency or not. So first section, buyer authorizes the firm to act as a dual agent. And for the second blank says buyer desires exclusive representation at all times and does not authorize. If they choose to miss out on all of the listings of our firm, again, we have the market share in the area, then they would choose the second one. And as a policy, when it comes to authorization, if they choose dual, we would also highly recommend that designated is chosen as well. Now, here's the thing, it can be changed later. If only dual is selected in the beginning and you're not looking at any properties or listings advertised by the firm, you're looking at other firms' listings, that's okay. But if they are most interested in and have a good shot of getting the property, then designated can be chosen at that time. All right. 14F speaks to the compensation if dual agency arises. And typically our firm expects 6% on the listing side. So that's the percentage that would go in this blank. If the firm acts as a dual agent, the total fee the firm expects to receive for its services in representing the buyer and seller should be 6% of the contract sales price. Now, that's not to say we always know what's going on the listing side. However, because that's what we expect, that's what can go here. If you wanted to add some additional language to that, it could be 6% of contract sales price or what is listed or what is advertised or stated in the listing agreement. Okay.
That's what I have learned to do is
Yes,
6% of contract price or whatever is in MLS, and that eases the buyer's mind. So
yes, exactly. Love it. All right. Okay. All right.
I've done so many of these.
It's like you know them by heart now, right?
Oh, no doubt about it. Yeah.
Just fill in the blank. You don't even read it anymore. Just fill in the blank.
I am looking for compliance. Exactly. I mean, I'm here for compliance.
Yes.
So.
Yes. 15, mediation, of course, if there's a dispute that arises between the buyer and the firm, we agree to mediate and not take each other to court. Yeah, we don't want, that's a long drawn out process. We agree to mediate. Paragraph 16, entire agreement, changes and termination. This agreement constitutes the entire agreement between buyers and the firm. If there's any changes, we need to have them in writing or create some addendum to it. But again, we would just change it. If there's going to be termination, we agree to mutually terminate the agreement. All right, 17, surveillance just speaks to properties that the buyer may be viewing. Then they just know that there could be some type of audio or video surveillance. Photographs and videos, again, same thing. Excuse me, unless a buyer is to, or unless we're told not to, or to instruct our buyers not to, photos are okay. You know, photos or videos or even.
I actually encourage it, but tell them you cannot put it online. You can't share it. Okay.
Yep, exactly. I love that. I love the education of that. Absolutely. Absolutely. Love that.
This is trial and error.
That's basically everything that I've, you know, a lot of what I've learned is through, and mess ups. Yeah, I've had some mess ups in there too.
No doubt.
Oh, absolutely. Okay, so that's paragraph 18. Paragraph 19 speaks to wire fraud. I will say here, I do not possess any wiring instructions on behalf of anybody. I don't obtain wiring information. I have buyers to contact the attorney directly, contact the bank directly. I don't handle any of that.
That is me too. Yep.
Sorry about that.
I don't want it. I can't email it. I can't do anything. Nope.
Exactly. And I encourage them to go do it in person if they possibly can.
In person at the attorney's office. Yes, exactly what I tell them.
Yes, in person, go in person. Yes. And that just, you know, puts everything to a very low, you know, at a minimum.
At a minimum, yeah.
Yes, exactly. All right, and here we are at the buyer's information on the agency agreement. It's okay to put their information there because that's property of the firms. It won't be shared, of course, with anyone else. If it's an entity, it goes there, and here's our information. And that is buyer agency. But I do quickly want to bring up the affiliated business disclosure just so you can see it quickly.
I do want to see it, please.
Yes. So let me bring that up. Let me open it here. Where is the affiliated business disclosure?
We had one at my other firm, but it was a single page. It was just a disclosure.
Gotcha. We did have one single page, but I'll tell you, it was so much controversy over that because it appeared that the buyer had to choose it if they signed it. And we wanted to get rid of that confusion.
No, we had a checkbox if they wanted it. If they didn't want it, they just signed the disclosure. So, but 2 forms is fine too.
Yeah, and that's what I really wanted, but Heritage wouldn't do that for us. They had, I guess they split it up, had to split it up. Okay, so let me go here.
Attorneys look at things different ways.
Exactly. We wanted can you just change the sheet? And they said, right. No, we can't do that. So, okay. Whatever works.
Exactly.
All right, so here is the disclosure, okay? In the beginning, of course, you're not going to know the property address because you're just going to be showing. I do think best practice is to get it signed with the agency agreements. Of course, you can put the buyer's name, but you will not have a property address at this point because we're only disclosing that we have a relationship. Here it goes on to explain what Heritage title is, what the costs are, how it's calculated, and then acknowledgement that we've read the disclosure. We understand that Keller Williams is referring me or us to purchase the above described settlement services, and we may receive financial benefit or some other type of benefit as a referral. Merely acknowledging. That's the one page. So
that's not something that the agent would get them. That's something that the firm gets, but not the agent.
Exactly. That is correct. The firm. It's the firm. Okay. All right. So that's the disclosure. Now, let me show you and bring up the selection form. And there's the selection. It's right there. All right, and here's the selection form. Now, here is where, again, definitely put the buyer's name. But if they don't get that first property, no need in putting in that address yet. I go ahead and do this with the first offer. Buyer's name there. I do not put in the property address until there's a contract. However, they can acknowledge down here or select in section 3. Here's their election, and it says, I request that my title insurance business be referred to Heritage Title and my closing attorney or closing agent be notified accordingly. I further understand that I can contact Heritage Title to obtain or provide additional information. So they can check box 1, or they can say or choose box 2. I request my title insurance business be referred to, if they have one that they want to use, maybe they want to use their old title insurance. If they're selling a property, they can choose to do that here. Or box 3, I would like my closing agent or attorney. I'm sorry. I guess it's going to be either this one or that one. Oh, okay. They're putting in here their attorney's name. I would like my closing agent or attorney to be, and whoever the agent or closing agent will be. So 1 is yes, I'm choosing them. 2 is no, I'm not. And if they're not wanting to use anyone, you would just do NA in that box.
Even if it's not checked, I have to put NA in the box?
No. Only
Okay.
if they say, so if they check box 2, they're just saying, I'm not using Heritage. I'm not using Heritage. And if they don't have one,
But they would have to name one if they want the closing attorney. Oh, I would like my closing agent or attorney to be,
So if they know who
I
they're,
get you. Okay, that makes sense. Okay,
yes, yeah,
that makes sense.
yes. And so that's what you're, and of course this form would be delivered to the attorney's agent. Now, if they are electing not to use Heritage, it's no need to even give the form to the attorney unless they have someone they want to use.
But we have to have it in command for compliance.
Yes, that
And
is
it has
correct.
to be signed.
Yes.
If they refuse, absolutely refuse, and then you just write refuse to sign,
Yep.
and scan it in like that. Okay,
There you go. That's it, right there.
thank you so much.
You're so welcome. And that's all of the forms for buyer agency and getting those offers written and done. Any questions or anything else you can think of, Rusty?
I think I'm probably asked all my questions. I like to interact, so I mean, I like in person better, but the Delta variant has me scared.
Yeah.
So yeah,
I got you. No explanations required. I understand. Okay, well, that is all we have for today, and I did good. I'm getting off of Zoom for them to go ahead and prepare for team meeting. Join us at team meeting, 12 o'clock, same link.
I came in person to the last one, so yeah.
Okay, well, I'll be there. I'm home now because I didn't want to be in their way. So I am packing up, headed to team meeting.
I won't be there in person today, but I will be there Zoom. So yeah.
Okay, all right. Well, I will probably see you / hear you.
Thank you so much. I appreciate it.
Okay, thanks, Rusty. Have a great day. See you. Oh, tomorrow it's going to be a video.
Right.
Video Wednesday, video Thursday. Okay.
Wednesday, Thursday videos. Yeah.
Yes. All right.
The last one. Yep.
Log on.
That'll work. See ya.
All right. Thank you. Bye.